I would like to make you aware of a 70-year inequity in the Massachusetts General Law. Chapter 32, Section 94, also known as the Hart Law. Under the Hart Law, publicly employed police officers may be granted protection for disability caused by heart disease or hypertension. However, some 400 publicly employed police officers are not covered. Those not covered include the University of Massachusetts Police, the Environmental State Police, the Department of Mental Health Police, the Massport Police, and those of our state and community colleges. How did these officers get left behind? Well, when the Hart Law was enacted in 1950, the legislature drafted it using a then-current definition of police officer. When this took place, several agencies were simply forgotten or did not exist in their current form. Officers from the forgotten agencies have applied to MSRB for protection and been denied. The judiciary concluded that while petitioning officers met the definition of full authority civil service police officer and adhered to the NPTC standards of training for municipal police officer, because the agency was not specifically listed in the law, they were not entitled to the provisions. The judiciary further indicated that they would not legislate from the bench, and a change to the law would be necessary. In the 2020 police reform, publicly employed Massachusetts law enforcement officers are defined as equals under MGL Chapter 6E Section 1. The definition of law enforcement officers is all-inclusive and requires us all to meet the same training and post-certification standards and adherence to the same criminal procedural law standards. The legislative intent is clear. Everyone that holds or exercises police powers must meet the same requirements and standards. After adopting the all-inclusive provisions of police reform, what articulable justification does the legislature have to continue the 70-year exclusion of publicly employed police officers from the Hart Law's applicability, while in recent years adding additional categories of firefighters? The financial liability for such a correction is very limited in scope. The science reinforces this point. An American Heart Association study concluded the average age of a police officer who suffers a heart attack is 49 years old. These afflicted officers in most cases have served more than 20 years as publicly employed police officers of the Commonwealth and have been paying into the pension system the entire time. It is their own pensions that they will receive when heart disease precludes them from completing their full number of years of credible service. An International Journal of Emergency Mental Health study cited by NPTC Longevity in Law Enforcement Training indicates the life expectancy of a police officer is roughly 22 years, less than that of the general population at 55 versus 77. NPTC in Service Training cites a 2013 Harvard School of Public Health study stating police officers face a 30 to 70 times greater risk of cardiac incident when they are involved in stressful situations. Line-of-duty heart attack, death, and occupational links to police cardiac disease do not discriminate between race, ethnicity, age, or police agency. We have formed a growing coalition of support to include many major police labor unions, the Massachusetts Police Association, the Fraternal Order of Police, and unanimous support from the Massachusetts Chiefs of Police Association representing all 351 municipalities of the Commonwealth. What we are asking is simple. Fix the 70-year inequity in the Hart Law. In the 2020 police reform, the legislature itself cemented an all-inclusive definition of Massachusetts law enforcement officer. Now we ask that you treat us all the same and bring us in line with all other publicly employed police officers of the Commonwealth. Voice your affirmative support for those forgotten state and special authority police that work to protect and serve at the Commonwealth's public colleges and universities, in its coastal ports, in its forested lands and parks, in its state hospitals, and alongside our municipal, transit, and state police colleagues. 70 years of inequity. Equity cannot wait any longer. Co-sponsor today.
Call the leadership.
Make this bill a priority. In the 193rd General Court, this bill favorably reported out of the Joint Committee on Public Service. It went to Senate Ways and Means where it languished. The judiciary has called for a change. 70 years is enough. Equity cannot wait. Disabled publicly employed police officers need your support. Sign on to SD539 or HD3538 today.